This is a review of LEEB Chapter 9, Intellectual Property. Note that this review also covers internet law, and this content is not contained in the required text, so pay special attention to that content also. After reading this chapter and reviewing this video, we should understand the following: why it is important for the law to protect intellectual property, under what authority Congress regulates intellectual property, how intellectual property is protected, what the differences are between major forms of intellectual property protections, what current ethical issues arise under intellectual property law, and what role internet law, social media, and privacy play in the business environment. Intellectual property is any property that results from intellectual creative processes. It is the product of an individual's mind, and it is imperative to businesses. They are intangible assets for which exclusive rights are granted by law. The framers of the Constitution recognized the importance of protecting creative works and provided for such protection in Article 1, Section 8 of the Constitution. The Intellectual Property Clause, which is Article 1, Section 8, Clause 8, grants Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This clause gives Congress the authority to grant limited monopolies to both authors and inventors and applies to copyrights and patents, respectively. And then there is the Commerce Clause, which grants Congress the power to regulate commerce. This clause is the constitutional root for our statutory scheme for trademarks. Statutory protection of intellectual property rights began in the 1940s and have evolved to meet the needs of modern society and keep up with developing technology. Even though we live in a capitalistic world and we have outlawed monopolies generally, the constitutional and statutory framework of intellectual property allows for limited monopolies in order to strike a balance to promote progress of science and useful arts. Financial incentives to producers encourage progress. The end of the limited monopoly signals progression because society can improve upon the producer's products. Ultimately, Congress decides when the exclusive right or limited monopoly ends. Now, let's take a quick look at each form of intellectual property and note some of the differences between them before we go into them in greater detail. Depending on the work, intellectual property falls within one of these four categories: patents, trademarks, trade secrets, and copyrights. Patents protect inventions, original designs, and novel processes that are new, useful, and non-obvious. In this iPhone example, a patent covers the user interface and display of the iPhone as functional aspects of this product. Trademarks are distinctive words, symbols, or devices that a producer of goods or services affixes to those goods in order to identify, in the mind of the consumer, the source of the goods or services. Here, the Apple logo and the trade dress of the iPhone are protected under trademark law. Next, we have trade secrets, which are secret, confidential business information used by a person or a company in manufacturing their goods or services. Trade secrets are a special form of IP in that they must be protected by the holder of the secret and not by the government. Copyrights protect the expression of creative, artistic, or literary works. Here, the software embedded in the iPhone are protected by copyright law. Our first form of IP is a patent, which is a grant from the government that gives an inventor the exclusive right to make, use, or sell their invention. The term of a patent varies depending on the type of patent, and by term I mean the duration of a patent. In the instance of a utility or a plant patent, the inventor gets a limited monopoly for a period of 20 years. If it's a design patent, however, then the limited monopoly is granted for a term of 14 years if it's granted before 2013 and 15 years if it's granted after 2013. The patent term starts to run from the earliest United States filing date, not when the patent is issued. When the patent term expires, then the invention goes into the public domain. So, a patent gives the holder the exclusive right to exclude competitors from making, using, or selling the invention within the United States, and it even protects the importation of imitations. There are three types of patents currently available in the United States. 1. Utility patents, which protects utilitarian features of a good or service. 2. Design patents. And 3. Plant patents. To have a patent granted, the subject matter of the patent must be patentable. Patentable subject matter includes processes, machines, manufacturers, compositions of matter, designs, and plants. So, patents protect inventions, original designs, and novel processes. Non-patentable subject matter is listed here. So anything that is a law of nature or a natural phenomenon or an abstract idea or things that are appropriately protected by other forms of intellectual property are not patentable. The first kind of patentable subject matter is a machine, which is a concrete thing consisting of parts or of certain devices and combinations of devices. Machines include every mechanical device or combination of mechanical powers and devices to perform some function and produce a certain effect or result. You should think of machines as parts that basically interact with each other. Examples of machines that qualify for utility patents are steam engines, television sets, electronic devices with convex displays like our iPhone example, and sewing machines. Next, we have a process patent, which is a form of a utility patent that covers the methods of changing the functionality or characteristics of a material during a particular use. Here, method or process means a series of steps that perform a function or accomplish a result. This type of patent includes computer programs and even business methods. Next, we have articles of manufacture, and those are tangible articles that result from the process of manufacture. An article of manufacture is a finished creation that has some utility, but it may not actually be mechanical or have moving parts. Articles of manufacture may have parts, but the interaction of those parts is usually static. These types of patents tend to cover simple inventions with few or no moving parts. Examples of articles of manufacture are Tupperware, ceramics, hammers, envelopes, and mouse pads. The last type of patentable subject matter for the grant of a utility patent are compositions of matter. These are defined as newly synthesized compositions of two or more substances and all composite or compound articles. These are compositions formed by the intermixture of two or more ingredients and can be the result of chemical union or a mechanical mixture, whether they consist of gases, fluids, powders, or solids. Even some living things like economouse and microorganisms may be patentable as compositions of matter. These types of patent claims cover any use of the claimed composition of matter. Some examples of patentable compositions of matter include new drug molecules or new compounds, new formulations of known drugs, new drinks or beverages like sports drinks, beer, vitamin concoctions, and new food recipes. So, new inventions here do not require that the ingredients are new, so long as the resulting combination provides something different than anything made before. So that would mean a transformation of natural products, and the end product could be described as a new composition of matter. So where a utility patent protects the way an article is used and works, a design patent protects the way an article looks. Both a design and utility patents may be issued on an article if an invention resides both in its utility and ornamental appearance. A design consists of the visual ornamental characteristics embodied in or applied to an article of manufacture. So the subject matter of a design patent may relate to the configuration or shape of an article, to the surface ornamentation applied to an article, or to the combination of configuration and surface ornamentation. But let's keep in mind that design patents and trade dress are not one and the same. We'll get to trademarks soon, but patents protect inventions. Trade dress, as a form of trademarks, help consumers identify the source of goods within commerce. While a design patent and trade dress may protect the same facet of a product, they are not mutually exclusive, and they may be granted either concurrently or consecutively. So an article of manufacture can be covered by a utility patent, a design patent, and trade dress all at the same time, assuming that the requirements for each form of protection are met. Examples of articles having design patents are the classic Coca-Cola bottle and the iPhone user interface. The next type of patentable subject matter and type of patent is the plant patent. A plant patent is granted to an inventor who has invented or discovered and asexually reproduced a distinct and new variety of plants other than a tuber-propagated plant or a plant found in an uncultivated state. Here, asexually reproducing means that the plant must reproduce by means other than from seeds, and their offspring arise from a single organism. A grant of a plant patent protects the owner's right to exclude others from asexually reproducing the plant and from using, offering for sale, or selling the plant so reproduced or any of its parts throughout the United States, or from importing the plant so reproduced or any part thereof into the United States. Here, algae and macrofungi are regarded as plants, but bacteria are not. If a plant does not meet the requirements for a plant patent to be granted, then it may be protected through the Plant Variety Protection Act, abbreviated PVPA. This IP statute affords protection for sexually reproducing new, distinct, and stable plant varieties. Under the PVPA, breeders are granted a certificate that has a similar protection to that of a utility patent. The certificate secures up to 25 years of exclusive control over plant varieties depending on the type of plant. PVPA protection cannot form the basis of a plant patent, but it can be protected under a utility patent. The PVPA grants the breeder the exclusive right to exclude others from selling the plant variety or offering it for sale or reproducing it or importing it or exporting it or using it in producing a hybrid or different variety. After we consider whether the subject matter of an invention is patentable, then we have to be sure our invention meets the requirements for patentability. For a patent to be granted, the subject matter must be patentable, meaning anything under the sun made by man, and it must be new, useful, and non-obvious. New means that the invention is novel, that the invention must be substantially different from anything else that is public knowledge. Public knowledge includes anything that has been previously patented, or anything that has been written about in a publication, or anything that is already being sold in the open market. If some knowledge is in the public domain, then that information is public and cannot be new for the purposes of a patent. No worries though, because an invention can be new if it combines two existing ideas. The scope of public knowledge extends worldwide, even though patents are not granted worldwide, since you kind of have to apply for a patent in each respective country. The useful requirement means that the invention must work and serve some type of purpose. It has to be functional. The non-obvious requirement means that the invention is not easily perceived by a person of expertise in that invention's particular field. This person of expertise is called a person having ordinary skill in the art, aka FOSITA. This requirement is a measure of what society accepts as a valuable discovery. So in theory, if an idea or invention is so obvious that FOSITA would develop it without much effort, or otherwise stated, if the invention is so obvious to FOSITA as a logical next step, then the incentives provided by the patent system are completely unnecessary to generate the progression of science, and a patent will not be granted. Once an invention meets the threshold requirements for patentable subject matter and patentability, then an inventor files a patent application with the United States Patent and Trademark Office, aka the USPTO. If a patent is filed after the effective date of the America Invents Act, which is March 2013, then the first inventor to file a patent on an invention, assuming it meets those requirements, will be granted a patent regardless of the actual date of the invention. As you can imagine, this creates a no-holds-barred race to the USPTO for inventors. Once the application is filed, then it is assigned to a patent examiner that is an engineer, scientist, or specialist in inventions of that kind. Patent examiners work closely with inventors to examine the application and determine whether or not a patent can be granted. Patent examiners search prior art to ensure that an invention is new and unique. They review applications to ensure conformity to formal requirements. Once they are going through the process, an applicant may use the patent pending indication on their product to ward off infringers. Once the process is complete, the USPTO issues a patent. An issued patent is presumed valid and must be challenged in order to rebut the presumption of validity. A patent is a trade-off. The inventor makes full disclosure of how their invention works to promote the progress of science, and in exchange, they get a limited monopoly over their invention. So, if a firm makes, uses, or sells another's patented design, product, or process without the patent owner's permission, that firm commits the tort of patent infringement. Patent infringement may occur even though the owner has not put the patented product into commerce. Patent infringement may also occur even though not all features or parts of a product are copied. However, to infringe a patented process, all steps or their equivalent must be copied. Let's look at an example. Apple sues Samsung in federal court, alleging that Samsung Galaxy smartphones and tablets that use Google's HTC Android operating system infringe on Apple's patent. Apple has design patents that cover its device's graphical user interface, which is the display of icons on the same home screen, the shell, and the screen and button design. Apple has also patented the way the information is displayed on the iPhones and other devices, the way the windows pop open, and the way information is scaled and rotated. A jury found that Samsung willfully infringed 5 of Apple's patents and awarded damages. Of course, the parties appealed. Later, the amount of damages awarded on the patent claims was reduced, but litigation between the two companies continued. In 2005, the Federal Appellate Court held that the elements of the physical design of these two manufacturers' mobile devices and their own screen icons were functional and does not warrant protection under the Lanham Act, referring to trade dress. A product's feature is functional and not protected as trade dress if it is essential to the article's purpose or affects the cost or quality of the article. As we see in that example, if a patent is infringed, the patent holder may sue for relief in federal court. The patent holder can seek an injunction against the infringer, and they can also request damages for royalties and lost profits. In some cases, the court may grant the winning party reimbursement for attorney's fees and costs. If the court determines that the infringement was willful, the court can triple the amount of damages awarded. That's called treble damages. In the past, permanent injunctions were routinely granted to prevent future infringement. Today, however, according to the Supreme Court, a patent holder must prove that it has suffered irreparable injury and that the public interest would not be disturbed by a permanent injunction. So, the courts have discretion to decide what is equitable in the circumstances and to consider what is in the public interest rather than just the interests of the parties. Our next form of IP is trade secrets. The law of trade secrets protects some business processes and information that are not or cannot be patented, copyrighted, or trademarked. Trade secrets consist of commercially valuable information, usually used in business, that is guarded from disclosure and is not general knowledge. That can include a formula, pattern, compilation, program, device, method, technique, or a process. Trade secrets may also include customer lists, plans, research and development, pricing information, marketing methods, production techniques, and generally anything that makes an individual company unique and that would have value to a competitor. Trade secrets are secret because if they were known, they would give some type of opportunity to obtain an economic advantage over competitors who do not know or use it. Unlike copyright and trademark protection, protection of trade secrets extends to both ideas and their expression. For this reason, and because there are no federal or state registration or filing requirements, trade secret protection may well be suited for software. Of course, a company's trade secrets must be disclosed to some people, particularly those key employees. But businesses generally attempt to protect their trade secrets by having all employees who use that protected process or information agree in their contracts or in confidentiality agreements never to divulge the trade secret. Courts also protect trade secrets by enjoining misappropriation, ordering parties that have misappropriated a trade secret to take steps to maintain its secrecy, as well as ordering payment of a royalty to the owner. If the information gets out in the public, then the trade secret protection will be lost. Independent discovery, like reverse engineering, will also undo trade secret protection. Trade secrets do not expire, so protection will continue until discovery or loss of the secret. Under Section 757 of the Restatement of Torts, those who disclose or use another's trade secret without authorization are liable to that party if either of the following is true. 1. They discovered the trade secret by improper means, or 2. Their disclosure or use constitutes a breach of a duty owed to the other party. Stealing confidential business data by industrial espionage or economic espionage, such as by tapping into a competitor's computer, is a theft of trade secrets without any contractual violation, and it is actionable by itself. Trade secrets have long been protected under the common law, but today nearly every state has enacted trade secret laws based on the Uniform Trade Secrets Act. Additionally, the Economic Espionage Act makes the theft of trade secrets a federal crime. Common examples of trade secrets include the ingredients that KFC puts in their chicken that make it finger-licking good, Google's search engine algorithm, the secret Coca-Cola formula, whatever McDonald's puts in its mac sauce, and even the ratio of water, malt, yeast, and hops used to make beer. Our next form of IP is a trademark, which is any logo, motto, name, device, sound, color, or look that identifies the origin of a particular good or service. A trademark owner can be an individual, business organization, or any legal entity. In fact, trademarks even help give business its identity and are displayed on company buildings. Generally, trademarks refer to marks used on goods, and service marks refer to marks affixed to services. For our purposes, the word trademark is going to be used to refer to both trademarks and service marks. A trademark must be used in commerce, affixed to a good or service. So it can appear on a package, a label, a voucher, or on the product itself. So when you think of trademarks, remember that this type of IP is premised on the concept of preventing consumer confusion by associating in the mind of the consumer the source of the product. For a trademark to be effective, it does not have to be federally registered or even registered in a state. If an entity uses a mark in commerce but has not registered that mark, they confer common law trademark rights, which are solely based on use of the mark in commerce within a particular geographic area. But registering a trademark federally generally enhances a trademark owner's rights and broadens the geographical area of protection nationwide. So when a party uses a mark in commerce, they have a trademark. Here, though, we will focus on the federal registration of trademarks. Also, we will get into domain names later when we get to the internet law segment, but let's be sure to note that there is a difference between a trademark, business name registration, and domain name. Registration of a domain name does not confer trademark rights. When you go to GoDaddy.com to host your website, they are giving you a domain name, not a trademark. Similarly, the use of a business name does not necessarily qualify as a trademark use if it does not satisfy the source indicating function. The registration of a business within a state also does not confer trademark rights. And a state's authorization to form a business with a particular name does not confer trademark rights. Specifically, trademarks allow customers or consumers to identify the maker of a product and avoid consumer confusion as to the source and quality of that product based on the company's goodwill. Statutory protection of trademarks and related property is provided for in the Lanham Act of 1946. The Lanham Act sets forth a number of requirements for a mark to receive federal protection. First, the mark must be used in interstate commerce. This element makes sense in light of our knowledge of Congress's Commerce Clause power and the authority to regulate interstate commerce. Second, the mark must be distinctive. Third, the mark cannot be barred from registration because of its content based on the enumerated list here. A trademark may receive federal protection if and only if it is distinctive. In this context, distinctiveness correlates to the strength of a trademark and works on a continuum or spectrum. This spectrum breaks down trademarks into classes, which are given differing degrees of protection. On the one side, which would be the right side, the more distinct a mark is, the stronger it is, and the more trademark protection is afforded to it. On the other side, which would be the left side, the less distinct a mark is, the weaker it is, and the less likely it is to be afforded trademark protection. So, the category in which a mark falls will significantly impact both its registrability and the owner's ability to enforce their rights in the mark. Our first class of distinctiveness is generic. This class is the weakest one of them all. Generic terms are not capable of serving the trademark function of distinguishing the source of goods and services, so they cannot be afforded any legal trademark protection. Generic terms cannot be registered and they are not enforceable against third parties. Generic terms are inherently not distinctive and have no trademark protection. Generic terms or marks are a common name for a good or service in connection with which it is used. Because generic terms are the common everyday name for goods and services, and everyone has the right to use those terms to refer to their goods and services, they are not protectable. So be aware that if you adopt a generic term to identify your goods or services, you will not be able to prevent others from using it to identify potentially competing products or services. For example, the term bicycle, when used in connection with bicycles or retail bicycle stores, is generic. The term milk, when used in connection with a dairy-based beverage, is also generic. And the term salt, when used in connection with sodium chloride, is definitely generic. Our next category of distinctiveness is descriptive. Descriptive terms or marks actually describe an ingredient, quality, characteristic, function, feature, purpose, or use of a good or service. If a mark describes a good or service, then it does not and cannot identify the source of the goods or services. So, descriptive terms are not distinctive and receive no trademark protection. So, for example, the mark 104 key, when used in connection with computer keyboards, would merely describe the number of keys on the keyboard. Thus, the mark is not distinctive and would not receive trademark protection. Also, the mark light, when used in connection with a low-calorie beverage or food, would merely describe the goods lacking calories. Thus, the mark is not distinctive and would not receive trademark protection. But what about the mark Best Buy, or IBM, which stands for International Business Machines? Doesn't Best Buy, when used in connection with electronic stores, merely describe that the store offers low prices? Or doesn't International Business Machines, when used in connection with computers, merely describe that the devices are made and sold around the world? The answer is yes, but we also know that these marks are protected. And that is because they fall within an exception to the descriptive general rule. Descriptive marks will receive trademark protection if the mark has secondary meaning. Secondary meaning means that the primary significance of the mark in the minds of the consuming public is the source of the goods and not the goods themselves. Think of it like this. When you, a consumer, come to identify a mark with a certain product over time, then that mark has acquired distinctiveness. There is no question in your mind about the source of the goods or services. So, if someone told you that they bought some Beats by Dre from Best Buy, then you would immediately know the source of the goods. Because these marks indicate the source of the product in the mind of the consuming public, then these marks have achieved secondary meaning and they are afforded trademark protection. The next classification is suggestive. Suggestive marks suggest but do not describe qualities or a connection to a product. These marks tend to indicate the nature, quality, or a characteristic of a product in relation to which it is used, but it does not describe this characteristic. These types of marks invoke some type of imagination, thought, or perception from the consumer, requiring them to make some inference to ascertain the nature of the goods. Suggestive marks are inherently distinctive and receive trademark protection. Examples of these types of marks are Jaguar, when used in connection with a motor vehicle that goes fast, or Extended Stay America, when used in connection with a hotel franchise that has rooms that allow for longer stays, or Chicken of the Sea, when used in connection with canned tuna, especially when chicken do not live in the sea. In each of those examples, the consumer has to make some logical inference to ascertain the nature of the goods covered by the mark, so they are suggestive. The next class of distinctiveness is arbitrary. An arbitrary mark is usually a common word that is used in a completely meaningless context. These terms have some dictionary meaning, but they are used on a good or service that have nothing to do with the term. Arbitrary marks are inherently distinctive and they receive trademark protection. Generally, these types of marks attain secondary meaning faster than other types of marks. Examples of arbitrary marks include camel, when used in connection with cigarettes, Vans, when used in connection with shoes, and Apple, when used in connection with computers. The last class of distinctiveness is fanciful. A fanciful mark is completely made up. It's a coined word or image that has absolutely no meaning within a given language. Fanciful marks are inherently distinctive and receive trademark protection. Fanciful and arbitrary marks are the strongest and most easily protectable types of marks, since it is less likely that anyone else is using them. Examples of fanciful marks include Kodak, Clorox, and Pepsi. Now, even though fanciful marks are one of the strongest categories of marks, they are the most likely to be susceptible to what we call genericide. Genericide refers to the death of a trademark by loss of its distinctiveness and trademark protection. Effectively, these terms become generic because of some long-term, widespread, non-trademark use. A fanciful mark that is very strong can, over time, become generic if the owner either starts using the mark in a non-trademark manner or fails to police the use of its mark properly and take appropriate action. Without the proper policing over time, the original owner of a mark could lose any trademark rights it has in the mark. So, for example, when a company came out a little while ago with a product consisting of a giant tub that can accommodate water and had air jets to blow bubbles, they called it jacuzzi. Over time, other companies made variations of that product, and consumers referred to all giant tubs with air jets as jacuzzis. At that point, the term jacuzzi no longer indicated the source of a good. Instead, it identified a broad classification of similar goods. So jacuzzi suffered from genericide, and it no longer afforded trademark protection. Other examples of marks that have suffered from genericide include aspirin when used in connection with pain relief medication, trampoline when used in connection with an article used as a springboard and landing area, escalator when used in connection with a moving set of stairs, yo-yo when used in connection with spinny thingies on strings, and heroin when used in connection with a pharmaceutical or not drug. Each one of those examples were once a valid, registered, inherently distinctive, fanciful trademark covering those goods until they were killed through genericide. Also, Xerox has gotten pretty close to genericide in recent times, but it has not gotten there yet, as they have been sure to police the use of their mark and take the appropriate action against misuse. Now, let's look at what can be trademarked. Keep in mind that a trademark may be comprised of any combination of names, logos, devices, sounds, colors, scents, what have you. So first, designs can be trademarked, and they are called either design marks or special form marks. Design marks are comprised of stylized words, letters, numbers, or a combination of the above and or a designed element. The design may appear by itself or combined with the stylized letters, words, and numbers. With a stylized mark, a trademark owner is limited to protection for the chosen font, color, or design that they submit to the USPTO. If a design mark is comprised of artistic works, then it is imperative that the trademark applicant also hold the copyright in that work in order to receive trademark protection. The design must be carefully described in a trademark application using the USPTO design codes. These codes are about 6 digits long and describe each and every element of the design. Here you can see a special form mark for Coca-Cola, stylized in a particular font. When applying for these types of marks, the rights to use the stylized mark would be limited because it does not allow for the owner to use the mark in any manner. So, if the owner changes its logo design, color, or font, then they will have to file a new trademark application to protect a future change. Then there are word marks, sometimes called standard character marks. Word marks consist solely of words, letters, numbers, or a combination thereof. A word mark makes no claim to design elements, stylization of the letters or numbers, color, or size. When applying for these types of marks, the trademark would be protected for the core of the trademark, such as the structure and the pronunciation of the mark. Registering a trademark in standard characters provides a broad set of rights for the owner and allows the owner to use those words, letters, and numbers in any way without the worry of losing the benefits of trademark protection. Here, you can see the standard character mark for Coca-Cola. Next, we have sound marks. Those are trademarks where sound performs the source identifying function. Sound marks receive federal trademark protection if and only if they assume a definite shape or arrangement and they are used in a way that creates an association between the sound and a good or service in the mind of the consumer. Commonplace sounds, like those that listeners have been exposed to under different circumstances, must have acquired distinctiveness in order to afford trademark protection. Examples of commonplace sounds include alarm signals, telephone sounds, and personal security alarms. Distinctive sounds include things like the NBC chimes, and the MGM's lion roar. Next, we have scent marks. So the distinctive smell of Play-Doh, or the scent of specialty embroidery yarn, or maybe that musky scent in the Verizon wireless stores, are all scent marks. These are pretty difficult to get, particularly because an applicant has to prove that the fragrance is not a functional aspect of the good or service, and they have to also prove that the scent is distinctive as a source identifier. So a trademark will not issue for the scent of candles, perfumes, and deodorant because in those instances, the scent serves a utilitarian function. And lastly, we have color, like Jay-Z blue, UPS brown, Tiffany & Company blue, and T-Mobile's magenta. All of those colors have trademark protection. For color to have this type of protection, they must have secondary meaning, aka acquired distinctiveness, and the color cannot be functional. Remember, the consumer must equate, and in the instance of color, that means visually equate, a specific color with a brand in order for distinctiveness to be acquired. Evidence of acquired distinctiveness may include evidence of sales successes, advertising expenditures, length of use, exclusivity of use, unsolicited media coverage, and consumer studies. Now let's take a look at some types of trademarks. First, we have trademarks. That refers to a mark used to identify or distinguish goods. Trade dress, trade names, and domain names may also be a type of trademark. Trade dress is a design or packaging that serves as a source identifying function, and it is distinctive, but it cannot be functional. An example of trade dress would be the appearance of Chipotle. When you think of or walk into a Chipotle restaurant, I'm willing to bet that you know that it's a Chipotle, even if all of the Chipotle signs were removed. That is because the dress of the restaurant serves as a source identifier. Next, trade name. Specifically, that is the official name under which a company does business. A trade name identifies and distinguishes a company or business from another. Trade names are protected by states, not the federal government. A domain name may also qualify as a trademark when it is used in connection with a website that offers goods or services to the public. When a trademark is composed either in whole or in part of a domain name, neither the beginning nor the end have source indicating significance, so they are not included within the scope of protection. Then there are service marks, which identifies or distinguishes services. Next, there are certification marks, which are used to certify whether a good or service meets certain standards established by the owner of that mark. These marks may certify either the region or origin of a good or service, the quality of the material used in a good, the mode of manufacture, the overall quality of a good, or even the accuracy of a good. Next, we have the collective mark, which is a mark used by members of an association, cooperative, or other collective group to identify and distinguish their products or to indicate membership in a union, association, or other organization. So CPA, like the Certified Public Accountants, is a collective mark for the Society of Certified Public Accountants. And then lastly, there is the collective membership mark. These are used for the sole purpose of indicating membership of a collective group. Registration of a trademark with the USPTO gives notice on a nationwide basis that a trademark belongs exclusively to the registrant. The registrant is also allowed to use the symbol of R inside of a circle to indicate the mark has been registered. Whenever a trademark has been copied to a substantial degree or used in its entirety by another, intentionally or unintentionally, then the trademark has been infringed, meaning it has been used without authorization. Causes of action based on unauthorized use of a mark may take many forms under the Lanham Act, including a claim for unfair competition, trademark infringement, or dilution. Unfair competition is the dishonest or fraudulent rivalry in trade and commerce, which relates to the practice of passing off one's own goods in the market for those of another by means of imitating or counterfeiting the name, brand, likeness, size, shape, or other distinctive characteristics of the article or its packaging. When a trademark has been infringed, the owner of the mark has a cause of action against the infringer. To succeed in a trademark infringement action, the owner must show that the defendant's use of the mark created a likelihood of confusion about the origin of the defendant's goods or services. The owner does not need to prove that the infringer acted intentionally or willfully, or that the trademark was registered, although registration does provide proof of the date of inception of use. The most commonly granted remedy for trademark infringement is an injunction to prevent further infringement. Under the Lanham Act, a trademark owner that successfully proves infringement can recover actual damages plus the profits that the infringer wrongfully received from the unauthorized use of the mark. A court can also order the destruction of any goods bearing the unauthorized trademark, and in some situations, the trademark owner may also be able to recover attorney's fees. Trademark dilution is another cause of action related to infringement, which gives the owner of a famous mark the ability to forbid others from using their mark in a way that would dilute the mark's viability in the market, either by blurring the association between the mark and a product, or tarnishing the mark by associating it with products or services that have a bad connotation. Dilution diminishes the capacity of the famous mark to identify and distinguish their goods or services. In some cases, trademark dilution involves an unauthorized use of another's mark on products that are completely unrelated to the famous mark that dilute the strength of the famous mark in commerce. Here, a likelihood of dilution test is applied to determine whether dilution occurred. So let's look at an example. Samantha Lundberg operated Sambucks Coffee House, a small business in Astoria, Oregon, even though she knew that Starbucks is one of the largest coffee chains in the nation. When Starbucks filed a dilution lawsuit, the federal court ruled that the use of the Sambucks mark constituted trademark dilution because it created confusion for consumers. Not only was there a high degree of similarity between the marks, but also both companies provided coffee-related services, and they even marketed their services through standalone retail stores. Therefore, the use of the similar mark, Sambucks, reduced the value of the famous mark, Starbucks. Our last form of intellectual property is copyrights. A copyright is an intangible property right granted to the author or originator of a literary or artistic production of a specific type. Copyrights protect creativity, originality, and forms of expression. They do not protect ideas. To have a copyright, we have to have the appropriate subject matter. The work of authorship must be original, and the work must be fixed, and there are no real formalities. The appropriate subject matter of a copyright are listed here. Literary works include newspaper and magazine articles, computer and training manuals, catalogs, brochures, print advertisements, and books. Musical works include things like songs and advertising jingles. Dramatic works includes plays and radio or television scripts that are intended to be performed, and usually they include some spoken text or plot and directions for action. Pantomime is the art of imitating or acting out situations, characters, or other events. Choreographic works are the composition and arrangement of dance movements and patterns, usually intended to be accompanied by music. Pictorial, graphic, and sculptural works include 2- and 3-dimensional works of fine, graphic, and applied art, like maybe a greeting card or a postcard, stationery, holograms, computer and laser artwork, and jewelry designs. Motion pictures are audiovisual works consisting of a series of related images that, when shown in succession, impart some type of expression of motion, together with any accompanying sounds. Sound recordings are a recorded performance, often of another work, and architectural works are the original designs of a building created in any tangible medium of expression, including a constructed building or an architectural plan, model, or drawing. So, not listed here is software, but the Computer Software Copyright Act amended the Copyright Act to include computer programs in the list of creative works protected by federal copyright law. Generally, copyright protection extends to those parts of the computer program that can be read by humans, such as high-level language of a source code. Protection also extends to the binary language object code, which is readable only by the computer, and to such elements as the overall structure, sequence, and organization of a program. Courts have not extended copyright protection to the look and feel of computer programs like the general appearance, command structure, video images, menus, windows, and other screen displays, as that may be a violation of trade dress or trademark laws. The work of authorship must also be original for copyright protection. This means that the author must independently create a work and that it has some creativity. The work must also be fixed in a tangible medium of expression. This means that the work must be embodied in some medium that is sufficiently permanent or stable to allow for it to be perceived, reproduced, or otherwise communicated for a period of more than a transitory duration. For the fixation requirement, so long as the work of authorship is written down somewhere, or it can be reproduced in some way, or it is communicated for more than a short amount of time, then it is fixed for the purposes of copyright. It is important to note that a copyright is conferred to an author immediately when the work is fixed, because there are no statutory formalities required to secure copyright protection. So, for example, when we sing in the shower, no copyright is conferred because the song that we sang is not fixed. There is no way of reproducing or communicating the song that we sang. But if we recorded ourselves singing in the shower, then as soon as it is recorded, then it is fixed and a copyright is conferred on the author, which would be the person who's singing the song. When an author has a copyright, then they get this bundle of exclusive rights with respect to the copyrighted material. The owner of the copyright has the exclusive right to control the reproduction, distribution, performance, and display of the work, and even the preparation of derivative works. As with patents and trademarks, any one of those exclusive rights conferred to a copyright holder may be licensed to another for their use. The duration of a copyright varies depending on the author or number of authors. If there is one author, then protection continues until 70 years after the death of the author. If there is more than one author, then it continues until 70 years after the death of the last surviving author. Or if a company or publisher owns the copyrighted work, then it lasts 95 years from the date of publication or 120 years from the date of creation, whichever comes first. Whenever the form or expression of an idea is copied, an infringement of copyright has occurred. The reproduction does not have to be exactly the same as the original, nor does it have to reproduce the original in its entirety. If a substantial part of the original is reproduced, then the copyright has been infringed. To establish an infringement claim, there must be a number of elements met. First, there must be a valid copyright on the work. Second, there must be actual copying of the work. And third, the copying must constitute an inappropriate appropriation of one of the owner's exclusive rights. Although formalities like registration with the government are not required for a copyright to be granted, it is required to establish a claim of copyright infringement in a federal court. Copyright infringement may take two forms, direct or indirect. Direct infringement is a direct violation of the copyright holder's exclusive right or rights. Indirect infringement is when there is an intermediary involved that either contributes to the infringement or is vicariously liable for the infringement. Contributory copyright infringement holds a party liable for infringement where they induce or substantially contribute to the copyright infringement by another party. Here, the contributor must have knowledge of, or have reason to know, or reasonably knew of the infringement. Vicarious copyright infringement is based on the respondeat superior doctrine, which is a common law principle that holds employers legally responsible for the acts of an employee if their acts are within the scope and nature of employment. To establish vicarious liability here, there must be an instance of direct infringement even if the employer has no knowledge of the infringement. The employer must only have a financial interest in the infringement and the ability to control the infringement. An important defense to copyright infringement is fair use. Fair use is an exception to liability for copyright infringement. In certain circumstances, a person or organization can reproduce copyrighted material without paying royalties for the purposes of criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research. These are some pretty broad classifications or guidelines for what is fair, so the court will make the fair use determination on a case-by-case basis, considering factors like 1. The purpose and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for value of the copyrighted work. Next, the first sale doctrine is another rule of great importance in the copyright world. The first sale doctrine provides that the owner of a particular item that is copyrighted can, without the authority of the copyright holder, sell or otherwise dispose of it. Under this doctrine, once a copyright owner sells or gives away a copy of the copyrighted work, then the copyright holder no longer has the right to control the distribution of that copy. So, when we donate a book to Goodwill or some CDs or DVDs, Goodwill can sell those copies of the copyrighted work without infringing on a copyright because of the first sale doctrine. Those who infringe on copyrights may be liable for civil damages or criminal penalties. These range from actual damages or statutory damages imposed at the court's discretion to criminal proceedings for willful violations. Actual damages are based on the harm caused to the copyright holder by the infringement, while statutory damages, not to exceed $150,000, are provided for under the Copyright Act. Criminal proceedings may result in fines and/or imprisonment. A court can also issue a permanent injunction as equitable relief against a defendant when the court deems it necessary to prevent future copyright infringement. So far, we have covered a lot of information about intellectual property. This chart summarizes some of the key points. Now on to internet law. Cue dramatic echo effect. Law, The internet has shaped and changed our lives and our laws. It presents a variety of challenges for the law. So, in this section, we are going to focus on some internet laws that play a role in business operations and the management of intellectual property portfolios. So that Monty Python song is probably the reason why we call spam spam. Businesses and individuals are the targets of spam. Spam is the unsolicited junk email that floods virtual mailboxes with ads, solicitations, and other messages. Back in the day, spam was considered to be pretty harmless, but now spam accounts for roughly 75% of all emails. So many states, and in about 2016, that would be 37 states, and the federal government have attempted to combat spam by enacting legislation that regulates its use. There's no easy way of getting rid of this electronic junk mail, but there are some ways to reduce the amount of unwanted spam. Many state laws require senders of emails to instruct recipients on how they can unsubscribe or otherwise opt out of further email ads from the same sources. In California, most unsolicited commercial email advertisements are banned outright. There, no person may A. initiate or advertise in an unsolicited commercial email ad from California or to a California electronic email address, or B, advertise in an unsolicited commercial email ad sent from California or sent to a California email address. Federally, the CAN-SPAM Act of 2003, which stands for Controlling the Assault of Non-Solicited Pornography and Marketing Act, applies civil and criminal penalties to spammers and pretty much prohibits false and deceptive emails that originate in the United States. This legislation applies to any commercial electronic mail messages that are sent to promote a commercial product or service. This statute preempts, meaning it controls over state laws, kind of like how a trump card in the game of spades controls state anti-spam legislation, except for those provisions in state laws that prohibit false and deceptive emailing practices. The CAN-SPAM Act permits the sending of unsolicited commercial email, but prohibits certain types of spamming activities, like the use of a false return address, the use of false, misleading, or deceptive information when sending emails, the use of dictionary attacks, which is the sending of messages to randomly generated email addresses, and the harvesting of email addresses from websites through the use of specialized software. Each separate email in violation of the CAN-SPAM Act is subject to penalties of up to about $42,000. But arresting spammers really doesn't curb spam, as spam continues to flow at a rate of about 70 billion messages per day. So, after the CAN-SPAM Act, the United States found that the rate of spam we received from international sources dramatically increased. These transnational spammers were able to escape detection and legal sanctions because the Federal Trade Commission, aka the FTC, lacked the authority to investigate foreign spamming. So Congress came up with the U.S. Safe Web Act, also known as Undertaking Spam, Spyware, and Fraud Enforcement with Enforcers Beyond Borders Act. This legislation allows the FTC to cooperate and share information with foreign agencies in investigating and prosecuting these international spammers, spyware, and internet frauds. This legislation also provides a safe harbor for internet service providers, also known as ISPs, which are the organizations that provide access to the internet. These safe harbor provisions give the ISPs immunity from liability from giving the feds information concerning unfair or deceptive conduct in foreign jurisdictions. Next, let's take a closer look at domain names. A domain name is a part of an internet address or URL. Every domain name ends with a top-level domain, or a TLD, which is a part of the name to the right of the period after the second-level domain. There are about 22 TLDs, or top-level domains, in existence before 2012. The TLD often indicates the type of an entity that operates the site. So, .gov is an abbreviation for a governmental entity. .edu is an abbreviation for education, like at the end of your student email accounts. And .com is for commercial. The second-level domain, or SLD, is the name chosen by a business entity or individual registering the domain name. Competition for SLDs among firms with similar names and products has led to a number of litigious disputes. By using an identical or similar domain name, parties have attempted to profit from a competitor's goodwill. So, as you can imagine, there must be a distribution system for these domain names. The Internet Corporation for Assigned Names and Numbers, or ICANN, is a nonprofit organization that oversees the distribution of domain names and operates an online arbitration system. In 2012, ICANN overhauled the domain name distribution system and started selling new generic top-level domain names, or GTLDs. Initially, GTLDs sold for a price of $185,000 plus an annual fee of $25,000. TLDs are limited to those generic terms that we have come to know, but the GTLDs can take any form. By 2017, lots of companies acquired GTLDs, which essentially increased the total number of potential domain names and transitively has increased the total number of domain name registrars. So, in response to concerns from trademark owners about these new GTLDs, ICANN implemented some protective rights mechanisms to relieve trademark infringement concerns. First, ICANN created the Trademark Clearinghouse, which is a central location where trademark owners can register their marks and get certain benefits to identify and ward off potential cyber squatters and infringers. Second, some domain registries have created their own databases of domains that are protected marks and deliver a service wherein clients may block their marks from being registered as a second-level domain name by third parties. One of the goals of the new GTLD system was to address the problem of cyber squatting. Cyber squatting happens when a person registers a domain name that is the same as or confusingly similar to the trademark of another and then offers to sell the domain name back to the trademark owner. Because there's been so much litigation on cyber squatting, Congress passed the Anti-Cyber Squatting Consumer Protection Act, which is an amendment to the Lanham Act. The ACPA makes cyber squatting a crime when both of the following is true. 1. The domain name is identical or confusingly similar to the trademark of another, or 2. The one registering, trafficking in, or using the domain name has a bad faith intent to profit from that trademark. But even with this legislation, cyber squatting continues to present a problem for businesses, especially due to the frequent changes in domain name ownership. Another type of squatting, specifically typo squatting, sometimes falls beyond the reach of the ACPA. Typo squatting is registering a name that is a misspelling of a popular brand like .googl.com or apple.com. These types of sites get a lot of traffic, which usually translates into increased profits due to advertising revenues. But if the misspelling is significant, the trademark owner may have some difficulty proving that the name is identical to or confusingly similar to the trademark of their own, as the ACPA requires. And even more, businesses incur increased cost trying to protect their domain name rights because they attempt to register legitimate names and the illegitimate names and variations of their marks. Plaintiffs in an ACPA action can get either 1. Actual damages and profits, or 2. Statutory damages ranging from $1,000 to $100,000. Some defenses to an ACPA claim are registering the domain name in good faith or the First Amendment. Also, pursuing these types of lawsuits may be difficult, as some domain name registrars offer privacy services that hide the true owners of the websites. That pretty much makes it difficult to identify the cyber squatters, and it requires a lot of subpoenas to discover their identity. So court proceedings can get costly, so most of these cyber squatting disputes will settle out of court. And ICANN offers a Uniform Rapid Suspension, or URS, system that allows trademark holders with clear-cut infringement claims to obtain rapid relief and having the infringing domain name immediately suspended. Meta tags are also used to infringe on another's trademark. Meta tags are keywords that give internet browsers specific info about a web page. Meta tags can be used to increase the likelihood that a site will be included on search engine results, even if the site has nothing to do with the keywords. So in practice, that means that one site can appropriate the keywords of another site with more frequent hits so that the appropriating site will appear in the same search engine results as the more popular site. When that happens, such a use may be permissible if the use is reasonably necessary and does not suggest that the owner authorized or sponsored the use. As with all the other forms of IP, a company may permit another party to use a trademark or other intellectual property, even a domain name, under a license. A frequent license used with respect to software is the end user license agreement. So every time you download an app or use some software, you are entering into a license agreement wherein you are the only person obtaining this license to use that software, but not the ownership rights in it. Licensing agreements usually include some restrictions that prohibit licensees from sharing the file and using it to create similar software applications, or restrictions on the devices on which you use the app, or a limitation on the duration the user has permission to use the app. This concludes our review of this chapter. Great job, guys. If you have any questions, please feel free to send me a message in Canvas or ask me after class.